School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 4 Legal and Regulatory Framework for Financing and Investments of Business. Unit 9 Insolvency and Bankruptcy. Part 2.
Corporate Insolvency Resolution Process. Trigger point for initiation. A corporate insolvency resolution process may be initiated under Chapter 2 of the Code in respect of a corporate debtor that has committed a default. The trigger point for initiating the corporate insolvency resolution process is the occurrence of default. A default would have occurred when the debtor fails to pay whole or any part or installment of the amount of debt that has become due and payable. The debt has been defined under Code as a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. While a financial creditor is required to present record of default before NCLT for initiation of corporate insolvency resolution process, an operational credit must issue a statutory notice to corporate debtor in the manner provided in Code. The claim, financial debt and operational debt are defined in the Code. A claim means a right to payment whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. It also means right to remedy for breach of contract under any law for the time being in force if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. The corresponding obligation of the debtor to pay may arise out of a financial debtor or an operational debt. Who can initiate the process? The process for initiating corporate insolvency resolution may be initiated by number 1, a financial creditor, or number 2, an operational creditor, or number 3, the corporate debtor itself. Commencement by financial creditor. Application by financial creditor. A financial creditor may initiate the process either by itself or jointly with other financial creditors by filing an application before the NCLT if a default has occurred in respect of a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. A financial creditor is a person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. Ascertaining existence of debt default by NCLT. Within 14 days of receipt of application by NCLT, it must ascertain the existence of a default from the records of an information utility or on the basis of other evidence furnished by the financial creditor. If NCLT is satisfied that a default has occurred or the application made by financial creditor is complete or there is no disciplinary proceedings pending against the proposed resolution professional, it may by order admit such application. Under SICA, admission of reference made to BIFR was by way of an administrative act of registration of reference by the registry of BIFR. Now an order must be passed by NCLT. It appears that the corporate debtor need not be heard by NCLT while ascertaining the existence of default. The NCLT can reject the application if it finds that default has not occurred or the application made by financial creditor is incomplete or any disciplinary proceeding is pending against the proposed resolution professional. The NCLT is required to provide an opportunity to the applicant to rectify the defect in the application if the NCLT finds the application to be defective. The applicant must rectify the defect in his application within 7 days of receipt of such notice from the adjudicating authority. Date of commencement. The corporate insolvency resolution process shall commence from the date of admission of the application of financial creditor by the NCLT. Order of admission of such application shall be communicated by the NCLT to the applicant and corporate debtor and of rejection to the financial creditor within 7 days. Declaration of moratorium and public announcement. With regard to creditors, one of the fundamental principles of insolvency law is that insolvency proceedings are collective proceedings which require the interest of all creditors to be protected against individual action by one of them. Many insolvency laws include a mechanism to protect the value of the insolvency estate that not only prevents creditors from commencing actions to enforce their rights through legal remedies during some or all of the period of the liquidation or reorganization proceedings, but also suspends actions already underway against the debtor. Such a mechanism is variously termed as a moratorium, suspension, or stay depending on the effect of the mechanism. The code provides for a moratorium from creditor's action against the corporate debtor. Where the NCLT passes an order of admission of an application for commencement of corporate resolution process, the NCLT shall, by an order, number 1, grant a moratorium mentioned in Section 14. Number 2, appoint an interim resolution professional in the manner as laid down in Section 16 of the Code. And number 3, cause a public announcement of the initiation of corporate insolvency resolution process and call for the submission of claims immediately after the appointment of the interim resolution professional. Moratorium. The order to declare moratorium prohibits: number 1, the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in any court of law, tribunal, arbitration panel, or other authority. Number 2, transferring, encumbering, alienating, or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. Number 3, any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. And number 4, the recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. Exclusion from moratorium. The order of moratorium should not affect supply of essential goods or services to the corporate debtor, which shall not be terminated or suspended or interrupted during moratorium period. This is important to explore resolution of the corporate debtor as a going concern. Conduct of corporate resolution process by resolution professional. The resolution professional is responsible for the conduct of the entire corporate insolvency resolution process and manage the operations of the corporate debtor during the corporate insolvency resolution process period. For this purpose, the resolution professional has the same powers and must perform same duties as vested or conferred on the interim resolution professional. Resolution plan. A resolution applicant may submit a resolution plan to the resolution professional prepared on the basis of the information memorandum. A resolution plan means a plan proposed by any person for insolvency resolution of the corporate debtor as a going concern in accordance with Part 2 of the Code. As already mentioned, a resolution applicant means any person who submits a resolution plan to the resolution professional. The resolution professional shall examine such resolution plan received by him to confirm that each resolution plan is compliant of the specifications provided in the code. Approval of resolution plan by creditors. A resolution plan which confirms the conditions referred so far must be placed before the committee of creditors by the resolution professional for its approval. The committee of creditors may approve a resolution plan by a vote of not less than 75% of voting share of the financial creditors. The resolution applicant may attend the meeting of the committee of creditors in which the resolution plan of the applicant is considered. However, the resolution applicant shall not have a right to vote at the meeting of the committee of creditors unless such resolution applicant is also a financial creditor. Approval of plan by NCLT. The resolution plan as approved by the committee of creditors must be presented by resolution professional to the NCLT for approval. If the NCLT is satisfied that the resolution plan as approved by the committee of creditors meets the requirements of resolution plan referred under subsection 2 of section 30, it shall by order approve the resolution plan. The resolution plan approved by the NCLT shall be binding on the corporate debtor and its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. As a consequence of the order of approval, the moratorium order passed by NCLT shall cease to have effect. Following the order of approval of resolution plan by the NCLT, the resolution professional shall forward all records relating to the conduct of the corporate insolvency resolution process and the resolution plan to the board to be recorded on its database. Rejection of resolution plan. If the NCLT is satisfied that the resolution plan does not conform to the requirements of subsection 2 of section 30, it may by an order reject the resolution plan. Punishment for contravention of resolution plan. If a corporate debtor, any of its officers or creditors or any person on whom the approved resolution plan is binding under section 31 knowingly and willfully contravenes any of the terms of such resolution plan or abets such contravention, such corporate debtor, officer, creditor or person shall be punishable with imprisonment of not less than 1 year but may extend to 5 years or with fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees or with both. Time limit for completion of insolvency resolution process. The corporate insolvency resolution process provided in Chapter 2 must be completed within a period of 180 days from the date of admission of the application to initiate such process, that is, from effective date. The period of 180 days can be extended by NCLT up to a maximum period of 90 days. Therefore, the total period for resolution of corporate insolvency, including extended period, can be up to a maximum of 270 days. An extension can be granted by the NCLT on an application filed by the resolution professional only if instructed to do so by a resolution passed at a meeting of the Committee of Creditors by a vote of 75% of the voting shares, and if it is satisfied that the subject matter of the case is such that corporate insolvency resolution process cannot be completed within 180 days. Any extension of the period of corporate insolvency resolution process cannot be granted more than once. Appeal before National Company Law Appellate Tribunal. An appeal by a person aggrieved by an order approving the resolution plan by the NCLT may be filed before National Company Law Appellate Tribunal, hereinafter referred to as NCLAT, on certain grounds. These grounds are: number 1. The approved resolution plan is in contravention of the provisions of any law for the time being in force. Number 2. There has been material irregularity in exercise of the powers by the resolution professional during the corporate insolvency resolution period. Number 3. The debts owed to operational creditors of the corporate debtor have not been provided for in the resolution plan in the manner specified by the board. Number 4. The insolvency resolution process costs have not been provided for repayment in priority to all other debts. And number 5. The resolution plan does not comply with any other criteria specified by the board. Every such appeal shall be filed within 30 days. The NCLAT may allow an appeal to be filed after the expiry of the said period of 30 days if it is satisfied that there was sufficient cause for not filing the appeal, but such period shall not exceed 15 days. Appeal before Supreme Court of India. Any person aggrieved by an order of the NCLAT may file an appeal to the Supreme Court on a question of law arising out of such order under code within 45 days from the date of receipt of such order. The Supreme Court may, if it is satisfied that a person was prevented by sufficient cause from filing an appeal within 45 days, allow the appeal to be filed within a further period not exceeding 15 days. Fast track corporate insolvency resolution process. The code provides for a fast track corporate insolvency resolution process to be completed within a period of 90 days from the insolvency commencement date. The period of 90 days may be extended by a maximum period of 45 days by the NCLT on an application filed by a resolution professional. The resolution professional can make such application for extension if instructed to do so by a resolution passed at a meeting of the Committee of Creditors and supported by a vote of 75% of the voting share. Any extension of the fast-track corporate insolvency resolution process can be granted by the NCLT only once. Liquidation process under IBC 2016. Commencement. Liquidation order under this code is passed only where the corporate insolvency resolution and no resolution plan can be passed within the time provided or a resolution plan passed is not complied with. Liquidation in other cases or other grounds is dealt as proceedings for winding up under the Companies Act 2013. Grounds for passing order of liquidation of corporate debtor by the NCLT. An order of liquidation is to be passed by the NCLT in certain circumstances. These circumstances are: number 1. If before the expiry of the insolvency resolution process period, a resolution plan is not received for approval by the NCLT. Number 2. If it rejects the resolution plan for the non-compliance of the requirements specified. Number 3. If the committee of creditors decides to liquidate the corporate debtor at any time during the corporate insolvency resolution process, but before confirmation of resolution plan by the NCLT, and an application is filed by the resolution professional to pass an order to liquidate the corporate debtor. And number 4, if the corporate debtor contravenes the resolution plan approved by the NCLT, any person whose interests are prejudicially affected by such contravention can file a liquidation application. Public announcement. Where an order of liquidation is passed by the NCLT, a public announcement stating that the corporate debtor is in liquidation must be issued. The NCLT shall also require such order to be sent to the authority with which the corporate debtor is registered. Protection of all interested persons is linked to publicity requirements designed to apprise potentially interested persons that liquidation order has been passed. Individual insolvency. The Insolvency and Bankruptcy Code 2016 in its Part 3 provides for insolvency resolution and bankruptcy for individual and partnership firms. The significant features of Part 3 are: number 1. There exist two distinct processes in case of insolvencies, that is, automatic fresh start and insolvency resolution. Number 2. The code applies in all cases where the minimum default amount is rupees 1,000 and above. Number 3. The insolvency resolution process consists of preparation of a repayment plan by the debtor for approval of creditors. If approved, the DRT passes an order binding the debtor and creditors to the repayment plan. If the plan is rejected or fails, the debtor or creditors may apply for a bankruptcy order. Number 4. The creditors and the debtors are required to agree on repayment plan for restructuring debts and affairs of the debtor under the supervision of an IP. Such a repayment plan requires approval of 75% of the financial creditors. And number 5, the code prescribes a timeline of 180 days for the insolvency resolution process. Fresh start process. Under the automatic fresh start process, eligible debtors on the basis of gross income can apply to the Debt Recovery Tribunal, that is DRT, for discharge from certain debts not exceeding a specified threshold, allowing them to start afresh. Under this, an applicant may be made by eligible debtor for any debt other than secured debt which has been availed of 3 months prior to the date of application, excluded debt. Eligibility for a fresh start process application under the code are: number 1. Applicant should not own a dwelling unit and has a gross annual income of less than rupees 60,000 with assets of value not exceeding rupees 20,000. And number 2, aggregate value of the qualifying debt of such individual or partnership firm should not exceed rupees 35,000. In addition, the applicant should not be an undischarged insolvent and there be no other previous fresh start process applications submitted by him. Discharge order and its effects. The bankruptcy trustee should apply to the adjudicating authority for a discharge order either on the expiry of 1 year from the bankruptcy commencement date or within 7 days of the approval of the committee of creditors of the completion of administration of the estates of the bankrupt. The discharge order releases the bankrupt from all the bankruptcy debt. However, a discharge order will not be granted if the discharge, number 1, affects the functions of the bankruptcy trustee, number 2, affects the operation of the provisions of Chapter 4 and 5 of Part 3, number 3, releases the bankrupt from any debt incurred by means of fraud or breach of trust to which he was a party, and number 4, discharges the bankrupt from any excluded debt. Disqualifications provisions. On the bankruptcy commencement date, the bankrupt is disqualified from number 1. Appointment or acting as a trustee or representative in respect of any trust, estate or settlement. Number 2. Appointment or acting as a public servant. Number 3. Election to any public office. And number 4. Election as a member of any local authority. Cross-border insolvency. Cross-border insolvency arrangement with other countries. Sections 234 and 235 of the Code deals with cross-border insolvency. The central government may enter into an agreement with the government of any country outside India for enforcing the provisions of the Code. The central government may, by notification in the official gazette, direct that the application of provisions of the Code in relation to assets or property of corporate debtor or debtor, including a personal guarantor of a corporate debtor, as the case may be, situated at any place in a country outside India with which reciprocal arrangements have been made, shall be subject to such conditions as may be specified. Letter of request to a country. If in the course of insolvency resolution process or liquidation or bankruptcy proceedings, as the case may be, the resolution professional, liquidator or bankruptcy trustee, as the case may be, is of the opinion that assets of the corporate debtor or debtor, including a personal guarantor of a corporate debtor, are situated in a country outside India with which reciprocal arrangements have been made under Section 234. He may make an application to the NCLT or DRT, as the case may be, that evidence or action relating to such assets is required in connection with such process or proceeding. On receipt of such an application, the NCLT may issue a letter of request to a court or an authority of such country competent to deal with such request. Leading cases. Some important cases on IBC are: number 1. Innovative Industries Limited versus ICICI Bank Limited, Supreme Court CA number 8337 to 8338 of 2017. The Honorable Supreme Court held that in the event of any repugnancy between any state law and the code, in respect of matters related to insolvency and bankruptcy, the code would prevail over such state laws. Number 2. IDBI Bank Limited versus Blanco Infratech CPLB number 111/7HDB/2017. In this case, the NCLT denied appointment of interim resolution professional, that is IRP, on the ground that he was already handling 3 big assignments and had recently been appointed IRP for 2 large companies. Number 3. Lokhandwala Kataria Constructions Private Limited versus Nices Finance and Investment Managers LLP, Supreme Court CA number 9279 of 2017. The Honorable Supreme Court, in exercise of its inherent power to ensure justice under Article 142, allowed the parties to withdraw the insolvency application upon the undertaking of the appellant to pay the outstanding dues to the applicant as per the consent terms. Number 4. Surendra Trading Company versus Jaggi Lal Kamlapat Jute Mills Company Limited, Supreme Court CA number 8400 of 2017. The issues for consideration by the Supreme Court were with regards to relaxation of time period prescribed under IBC. Whether the time period of 14 days for admitting or rejecting an application by NCLT is directory or mandatory. The NCLAT held that such time period is directory in nature. Whether the time limit of 7 days prescribed under the code for rectifying or removing defects in the application filed by an operational creditor for initiating CIRP is mandatory. The Supreme Court, observing that in a given case there might be weighty, valid and justifiable reasons for not able to remove defects within 7 days, held this to be merely a directory provision. Number 5. Mobilox Innovations Private Limited versus Kirusa Software Private Limited, Supreme Court CA number 9405 of 2017. The Supreme Court held that while examining admissibility of an application under Section 9 of IBC, the NCLT will have to determine the 3 conditions mentioned under Section 5, Clause 6. It was held that the definition of the term dispute is an inclusive one, and the present case was not one where suit or arbitration proceeding had been filed before receipt of demand notice, only in which case the dispute must relate to the 3 sub-clauses of Section 5, Clause 6. Number 6. Arun Kumar Jagat Ramka versus Jindal Steel and Power Limited 2021 SCC Online SC 220. The Supreme Court decided on 15th March 2021 that a person who is ineligible under Section 29 Clause A of the Insolvency Bankruptcy Code 2016 to submit a resolution plan is also barred from proposing a scheme of compromise and arrangement under Section 230 of the Companies Act 2013. Number 7. Kalparaj Dharamshi versus Kotak Investment Advisors Limited 2021 SCC Online SC 204. The Supreme Court held that the commercial wisdom of Committee of Creditors, that is COC, is not to be interfered with, excepting the limited scope as provided under Section 30 and 31 of the Insolvency and Bankruptcy Code 2016. It stated that, and I quote, "The court ought to cede ground to the commercial wisdom of the creditors rather than assess the resolution plan on the basis of quantitative analysis." Unquote. Number 8. P. Mohan Raj versus Messrs. Shah Brothers Ispat Private Limited, Civil Appeal number 10355 of 2018. The Supreme Court in March 2021 decided that when an order of moratorium is passed under the Insolvency and Bankruptcy Code, parallel proceedings under Section 138 of the Negotiable Instruments Act against the corporate debtor cannot be allowed to continue, as the same will be covered by the bar under Section 14 of the IBC. Number 9. Lalit Kumar Jain versus Union of India, transferred case civil number 245/2020. The provisions of the Insolvency and Bankruptcy Code 2016 concerning the liability of the personal guarantors to the corporate debtors were upheld. With the decision in place, the creditors can now initiate insolvency proceedings against individuals such as promoters, managing directors, and chairpersons who stand as personal guarantors on the monies lent or goods and services extended to the corporate debtors. Number 10. Phoenix Arc Private Limited versus Paid Financial Services Limited and ORS, Civil Appeal number 2842 of 2020. The Supreme Court has held that a financial creditor which is not a related party to the corporate debtor at present can also be excluded from the Committee of Creditors, that is COC, if it is found that he was earlier a related party and had removed this label only to bypass Section 21 Clause 2 provision. Now let's summarize the unit. This unit explains the law and mechanism related to corporate insolvency resolution process for corporates in India. The unit commences describing the legal and regulatory situation in place prior to enacting of the Insolvency and Bankruptcy Code 2016. It further examines the need to adopt the Insolvency and Bankruptcy Code 2016, hereinafter referred to as IBC or the Code. It discusses the salient aspects of the code with the help of the leading cases.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.